Q. In the light of the apprehensions expressed against some of its provisions, critically analyze aims and rationale of the proposed new Financial Resolution and Deposit Insurance Act FRDI law. 250 words. The Indian Express. The wider FRDI provisions. The FRDI Act defines the resolution mechanisms being pushed by the government as an alternative to recapitalization. 1. Creation of Independent Resolution Corporation. At the center of the new scheme is the creation of a new independent corporation that would take over the task of resolution of bankruptcy in banks, insurance companies and identified systemically important financial institutions (SIFIs). The Resolution Corporation will also take over the task of insuring bank deposits, compensating depositors up to a specified maximum amount at present Rs.1 lakh in case of bank failure. 2. Classification of financial institutions. As part of its responsibilities, the CO Corporation is to be mandated to classify the financial institutions under its jurisdiction under different categories based on risk of failure, varying from low and moderate where the probability of failure is marginally or well below acceptable levels, to material or imminent, implying failure probabilities that are above or substantially above acceptable levels, and, finally, critical, being on the verge of failure. 3. Imminent firms. Under the radar. In cases of financial firms placed under the material or imminent category, the Resolution Corporation is to be given the power to I. Inspect the books to obtain information on assets and liabilities, I. Restrict the activities of the firm concerned, I. Prohibit or limit payments of different kinds, and I. Require submission of a restoration plan to the regulator and a resolution plan to it, if necessary, involving the merger or amalgamation. 4. Critical firms to be taken over. In cases identified as critical, the Resolution Corporation will take over their administration and proceed to transfer their assets and liabilities through merger or acquisition or liquidation with permission from the NCLT. Closing all options, the law prohibits recourse to the courts to stay the proceedings at the NCLT or seeking alternative routes to resolution. Since liquidation involves compensating stakeholders according to their designated seniority, depending on the net assets available, any stakeholder can be called upon to accept a haircut or loss, including holders of deposits more than the maximum amount insured against loss. www.insightsindia.com 12 www.insightsis.com. Issues with the Bill. 1. Scrapping of DICGC. The bill proposes the scrapping of the Deposit Insurance and Credit Guarantee Corporation set up in the early 1960s in the aftermath of the collapse of two banks, which guarantees repayment of bank deposits up to Rs.1 lakh in case a bank is liquidated. 2. No amount stated to be returned to depositor. The NA Resolution Corporation under the Finance Ministry will steer financial entities out of the woods and offer a similar cover for deposits. The essence of the bill on the extent of deposits to be guaranteed is a key source of concern, and may necessitate the need to revisit the existing Rs.1 lakh deposit guarantee, which hasn't been revised since 1993. 3. Categorization will precipitate failure instead of solution. Essence. Mere categorization in the material or imminent category will send out a signal. Banks so designated can become the target of the run, as depositors hearing failure would want to move out their deposits. Instead of resolving the problem of vulnerability to failure, the mechanism may actually precipitate failure. 4. No recourse for employees in case of resolution plan. The restoration and/or resolution plan, to be acceptable, may force a financial firm to accept amalgamation or merger. This would have implications for parties that are not responsible for the state of the firm, including officers, employees, creditors and small shareholders. 5. Conflict between Resolution Corporation and firm under scrutiny may arise on resolution plan to start with, while the Resolution Corporation and the regulator concerned will determine whether a financial firm is to be placed in the material or imminent category. The task of working out an acceptable restoration or renewal plan rests with the firm under scrutiny. That is, the responsibility of restoring viability is that of the bank, insurance company or SIFI, with the Regulation and Resolution Authority retaining the right to determine whether it has managed to reduce the probability of failure. Way forward. 1. Use bail-in sparingly. Bail-in should typically be used where continuing a firm's services is considered vital but its sale is unviable, not as a lazy default option. If lenders don't believe that a bail-in plan would salvage a firm, triggering the clause could end up causing the run on the bank instead of preventing one. With its thrust on initiatives such as the January Myojana and demonetization, the government has nudged more people towards the formal banking system. To ensure that those gains are not lost, the government must communicate more clearly the rationale behind the bail-in provision, and the circumstances in which it may ultimately be used, if at all. 2. Enhance the deposits to be returned in case of bankruptcy. Most importantly, it must enhance the amount of bank deposits that will remain safe under the new dispensation. 3. Lesson from Financial Stability Board. This resolution framework is merely the replication in the Indian context of the regime recommended by the Basel-based Financial Stability Board FSB. www.insightsinIndia.com 13 www.insightses.com. The FSB was established in the aftermath of the global financial crisis of 2007-08, which was centered around the United States, the United Kingdom and Europe. However, in those jurisdictions, the resolution of the post-crisis problem of potential insolvency of banks came through government purchases of equity and